affidavit of being printed in that Norwich Evening Sun. Printed on the 30th of July. That's required. I guess that at this time I would declare that the public hearing is open, and the procedure we're going to use tonight, because there are a number of changes, and a lot of them are the same changes repeatedly. I've asked Gary Locke and Ken Ryan to go give us a short synopsis of the changes, and then we'll open up for comment from the public.
I'll go to Ken. Go ahead.
You probably, most of you are well aware that we've had land use management in Oxford in place since the 1970s. We've upgraded once since then, and this is a second upgrade that we've worked on for over a year now. This time around we got interested in sound management. We tried that a few years ago, and the planning board and the town board got a little discouraged thinking we couldn't manage sound. Since then, a lot of communities are managing it, some nearby, and we got a copy of their ordinances and used some of their material as a model for ours. And so this time our upgrade's going to include sound management. We picked up the old tower law that needed attaching to something, and that's included this time. And you've probably seen the new upgrade that's been on Town of Oxford website and the list of changes. There's, as other towns have done, there's quite a bit of activity in the zoning ordinance that the town board asked us to move from the zoning board of appeals to the planning board. As I said, other communities have done that too. That's one activity we're going to do, and Jerry Locke's going to tell you about some of those changes.
I'm not going to go through each individual change. They've been printed, they've been published around. There's been opportunities for you to look at them. But as a general rule, just wanted to explain why these changes are taking place. First of all, we jointly felt that the planning board was much more in tune to the zoning regulations of the town than the zoning board of appeals. They meet infrequently, where the planning board meets on a regular basis and deals with these things on a regular basis. So that was the rationale for doing that. Now, the majority of the changes were precisely that, just changing that approval and regulatory aspect to the planning board. Now, the highlights of the changes in the ag district, under special exceptions still, well, the gas and oil drilling remains at that area. Also, material staging area was added. These material staging areas can spring up, they can be huge, noisy, disruptive to neighborhoods, and so we felt that the planning board should have some input if they are going to take place, that they would have a handle on meeting with whatever organization is doing this to help regulate that, to help our community. Another change is in all the three residential districts, the R1, R2, and RR3. Drilling for gas and oil has been removed from those, and they were originally in those areas, so that has been removed from those particular zoned areas. And no material staging area is listed in those areas either. That's not a change, it simply was not added, because the material staging area didn't occur in the previous ones. For the general commercial district, again, they have, with approval, oil and gas drilling is listed in there, and the material staging area under the special exceptions has been added to that area as well. So, the commercial district and the ag district are the only ones with the material staging areas that has been added to, so we can get those regulations, and they simply won't be added to at all for the residential areas. That, in a nutshell, is the changes.
Okay, if anyone has comments they would like to make to the board concerning these changes, please ask you to stand and state your name so we have that for the record. And I'd like to ask you to limit your comments to 3 minutes.
John Knapp from Oxford. Taking the liberty of making you board members a copy and also one for the secretary. This is to the Oxford Town Board regarding the Town of Oxford zoning ordinance, local law number 1-2007. Article 2, Section 2, which highlights the purpose of this ordinance, states, and I quote, "The provisions of this ordinance shall be to promote the health, safety, and general welfare of this community," unquote. Let's always keep this in mind. My main concern is for the proposed changes to Article 5, Section 8A1, Agricultural District, Paragraph B. Uses which may be permitted as special exception by the Planning Board. There are 2 items listed that require clarification. Item number 2 is the commercial excavation drilling for gas and oil. This has been removed from the same section of Article 5, Section 9R1, Residential District. If this board has deemed it unwise to allow drilling in one area of the town, how can it then subject the remainder of the community to those same risks? Item number 8, material staging area has been added. Again, this use will not be permitted in the residential area, yet it is deemed appropriate for those of us who happen to live in the agricultural district. The oil and gas industry is at our doorstep, and their use of unconventional drilling practices, such as high-volume fracturing, is not business as usual. How will the planning board decide what are acceptable levels of toxins and pollutants when issuing permits for special exception uses? How will we monitor compliance if we don't even know what is being released or stored? Who will pay for the monitoring? Are our local firefighters ready to be first responders? What happens when there is an inevitable spill? Who is liable for damages that occur? The oil and gas industry is exempt from many of the laws which the rest of us must follow. All these questions and many more need to be answered in an open and transparent manner before drilling can even be considered. I live in the agricultural district, and I am a contributing member to this community. We all deserve the same safeguards. I ask you, the members of the town board, please protect my health, safety, and welfare. Ban drilling for gas and oil and material staging areas in all districts in the town of Oxford, invoking Municipal Home Rule. I request this letter to be included in tonight's town board meeting minutes. Thank you.
Anyone else wish to speak?
Paul Brennan. First of all, I'd like to say that this is a public meeting being held tonight for the purpose of hearing comments and input from residents pertaining to the proposed 2014 law. Generally, following this open forum, a period of due diligence on the part of the governing body is required to consider any and all information or concerns they receive pertaining to this topic. Appropriate revisions and adjustments should be made if necessary and then presented to the public for a final approval. I would assume this procedure will be followed in this manner. To hold a hearing and not take time to thoroughly review any commentary offered would defeat the reason for this hearing. All right, to the body of my statement. I have two concerns in regard to the proposed 2014 law. Number one, the phrase drilling for oil and gas, which is present in the 2000 law under special exceptions allowed in the R1, RR2, and RM3 zoning districts, has been removed in the proposed 2014 law. I personally agree with this change because there is no harmony or compatibility between heavy industrial practices such as those involved in oil and gas drilling and the definition of residential characteristics as contained in the current 2007 law and the proposed 2014 Oxford Town Law. My concern is the addition of the phrase "but not limited to" in the description of special exceptions which may be allowed by the planning board. This terminology is not included in the current law under residential districts, and its presence in the proposed law renders the special exception category open-ended and confusing. Intent possesses legal weight in a court of law and may be a determining factor in the outcome of any litigation. If it is the intent of the board to restrict oil and gas-related activities in residential areas as demonstrated by the removal of the drilling for oil and gas phrase from the existing 2007 law, then it is concerned that the option to allow drilling is still available at the discretion of the planning board. The 2014 law lacks specifics as to the procedure or protocol to follow in the issuance of special exception permits, and therefore leaves the planning board unregulated in preserving the intent of the law. The Board of Appeals has very detailed procedure to follow in making zoning permit decisions. The planning board does not. Board of Appeals must give 10 days prior public notification. The planning board is not obligated, according to this revised 2014 law, to provide advance public notification or hold a public hearing regarding any pending special exception decision. Due to the fact that an agenda for planning board, this is no offense to you, Ken, due to the fact that an agenda for planning board meetings is generally not available, minutes of planning board meetings are not always recorded, and public access to any existing minutes is limited, this is cause for concern. A non-publicized, regular monthly meeting at which an unannounced special exception was under consideration could slip under the radar and would deprive residents of opportunity to offer input and possibly challenge any decision made. Any planning board meeting that will be deciding a special exception permit should give the usual 10-day public notification as the Board of Appeals is required to do. Any such meeting should be open to free public comment pertaining to the issue at hand. The Board of Appeals is required by town law to follow a criteria or guidelines in order to make any zoning decision pertaining to permit issuance. There is no written criteria for the planning board. There is no written criteria that the planning board is required to follow in making decisions about permits. Approval of permits cannot be a discretionary call, but should be based on an established set of guidelines to maintain consistency from permit to permit. This would avoid the possibility of discrimination in permit issuance and provide a basis for justification of the final planning board decision. Pre-established rules would also be helpful to applicants seeking a permit. Some examples of the Board of Appeals criteria that they must go through under Section 33, Original Jurisdiction Number 2. In any case, the granting of a variance will be in harmony with the intent and purpose of this ordinance, will not be injurious to the neighborhood. The use shall be of such location, size, character that will be in harmony with the appropriate and orderly development of the district in which it is situated, and will not be detrimental to the orderly development of adjacent districts and uses. This is the Board of Appeals has to go through this. Another one here, they should be concerned about the general character, I'm simplifying this, the general character and intensity of development of the neighborhood. Another, such that the use will not hinder or discourage the proper development and use of adjacent land and buildings or impair the value thereof. Now, there's nothing in the 2014 law that requires the planning board to do any of this. They have to provide no justification for the decision. If they have to answer to these things, they have to use this as what they selected from those to justify their decision. One more page. Okay, material staging areas. There's no precise definition of what they are, what materials can be stored on site, limits or restrictions such as duration of permit, setback from roads or adjacent properties, restoration of excavations, etc. I feel there should be more clarification on how this special exception will be regulated, especially if it involves the permitting of heavy industry. A criteria or guideline should be established to aid in permit decisions, similar to those for the utility communication towers. I thank you very much, and I ask that this be entered into the minutes.
Anyone else wish to speak? Mr. Gravitt?
Willard Bradley, Oxford resident. I've actually been on the pro side of gas, natural gas in Oxford. I'd hoped this meeting wasn't going to be just about natural gas, but it looks like that's what it is. So, I've had a change of heart here, and I've decided that it must be true that it is very dangerous. It should not be used, should not be developed here or anywhere else. And taking that into account, every house that has natural gas going to it in town has basically a pipeline going to it. Coming down the roads, the side of the roads, there's all gas lines that are buried through here. To me, that can't be safe for anyone. And the idea of using natural gas, obviously that couldn't be safe either. So taking all that into account, I'd like to suggest to simplify all of this that you've been going through and to make it easier for everybody to understand, I'd like to see the town actually ban the use of natural gas in the town and the village, which has to be compliant with town decisions. I think by doing that, it's only fair with one exception I suggested at the last town board meeting, is I don't think it would be fair to include commercial entities in that. They're trying to make a living, they're helping the whole town, the village and everything, so I think there should be an exemption for commercial use of natural gas, but I'd like to see all other natural gas in the town and village of Oxford banned from use. Thank you.
Anyone else like to speak?
My name is Stacy Edick. I live in Oxford. What's the limit for getting the written comments to you? The deadline?
I'm sorry?
What is the deadline for getting the written comments to you?
Well, this is the public hearing.
I thought there was a deadline beyond today for written comments. I thought I read that in the public notice, but I don't happen to have that with me.
I don't see it in the call. Communications must be filed with the town clerk on or as a public hearing. So it's right now.
Okay. My first question is, where's the town attorney this evening?
He's not here.
What has the town attorney said about the permit by special exception language in light of the New York State Court of Appeals upholding the bans in Dryden and Middlefield?
This isn't a question and answer. This is a public hearing on the changes being made. The town attorney has reviewed them. I will tell you that. He's reviewed
It
them.
seems like if you're having a public hearing about an ordinance, it would be a good idea to have the town attorney state what his ideas are about that ordinance. And also, I attended an information meeting about natural gas compressor stations. Scott Clark lives near a compressor station in Windsor. He said they've been violating the town's noise ordinance 24 hours a day, every single day for 3 years since they've been there. So I think that maybe next month I'll come and ask you to consider banning new compressor stations, because they're actually probably more dangerous than well pads. And I'm also going to ask that you invest in microphones and system so that people can hear you. It's bad enough in the town hall, but with the air conditioners running, I'm sitting 30 feet away from you and I can't hear anything that's being said. I was able to hear the two of you when you stood up because you raised your voices, but I can't hear most of what is said at town meetings, and those are public meetings, this is a public hearing. I think your voices should be amplified so that everyone in the room can hear you. Thank you.
Anyone else like to speak?
I'd like to just say something about what Stacy said about the hearing. I can't hear. Is it okay to talk? Is it okay to talk, Lawrence?
You said you couldn't hear.
I just would like to say, I'm another one on the same list.
Okay. Dan, do you want
Dan Taylor. So these zoning changes pave the way for gas drilling in the town. What I cannot understand is how this town board, or any town board, could welcome an industry that carries with it the threat of groundwater contamination.
Yes.
I know that the industry says that they haven't contaminated anybody's water well, but they have. We heard the tobacco industry claim for decades that they didn't cause any ill health effects from their products. We know differently now. To welcome an industry that brings with it these risks and employs deception to support its bottom line, I think is a dangerous thing to do.
Anyone else like to speak? Nita? Go ahead.
Thank you for this opportunity to speak about the proposed revisions. I understand from the public notice that the town board will be reviewing the environmental significance of the proposed local law as part of tonight's hearing. So I'd like to focus my comments specifically on the environmental significance and the unenforceability that's related to the addition of the material staging areas as a permitted use by special exception, in particular in the agricultural district because that's where I live. My husband and I live and maintain a farmstead in the agricultural district. We would never allow shale gas development on our property. The problem with gas drilling and all of the industrial ancillary activities associated with it is that even if we disallow it on our property, this does not mean we're protected from the pervasive environmental effects of those activities occurring next door or even miles away. We've seen this when we went down to Pennsylvania and visited families, had nothing to do with shale gas development, miles away, water contaminated, methane contamination. Material staging areas, according to the gas industry, because this is a gas industry term, includes, but is not limited to, storage of toxic hydrofracking fluids, mountains of silica sand, sludge, drill cuttings, post-drilling flowback, radioactive brine, and produced gaseous material. All of these compounds can leach into the ground They can be absorbed by our shared aquifers, and they can become airborne, thereby easily contaminating neighboring properties. By permitting material staging areas by special exception, the town board is effectively allowing the use outright. I know that there are members of the town board and the town planning board who feel that adding it as a permitted use by special exception gives the town some authority over the matter, that it gives them the legal authority to decide on a case-by-case basis to permit or deny a material staging area, or for that matter, drilling for oil and gas. But this really just simply is not the case. The New York State Court of Appeals recently and definitively upheld a town's legislative authority to regulate land use, but not its judicial authority to regulate the gas industry. And this is a really important distinction. In other words, under Municipal Home Rule, this board has a legal authority to pass legislation that would prohibit an activity for the, quote, protection, safety, health, and well-being of persons and property therein. That's out of the Municipal Home Rule law. However, the New York State Environmental Conservation Law, under that law, our town's judicial bodies, which includes the Zoning Board of Appeals and the Town Planning Board, have absolutely no judicial authority to regulate the operations and processes of the gas industry. Making a judicial decision on a case-by-case basis would be considered an attempt to regulate the gas industry, and any gas company can point directly to our zoning ordinance and make that case that a permitted use is just that, it's a permitted use, and that any special exception process associated with it is illegal and unenforceable. If the Oxford Town Board truly wants to protect our town and have legal and enforceable authority over this matter, please follow the example of Dryden and Middlefield and 170 other municipalities in the state of New York, and either prohibit or place a moratorium on shale gas development in our town. Thank you.
Anyone else like to speak?
I would like to say something. Chris Fuller, off Bradley Hill. First thing, I would just like to simply second the motion that everyone said tonight. I personally feel that hydrofracking is a very dangerous situation. The risk to me to contaminate our drinking water. I have drilled well, and many other people, and I believe they speak for a lot of other people. The risk is just not worth the benefit to us. I just formally ask this board to please reconsider your stance on hydrofracking. Please do what you can to keep it out of our town. Thank you.
Anyone else like to speak?
My name is Kathleen McBride Anderson, and I'd like to follow up on something that Will said earlier about the gas being dangerous, and it is. It's also limited in supply. And I'd like to follow up and say I support what he says in the sense that we should not have our focus on gas and oil, but on sustainable forms of energy. And I would like to see more of that promoted in our community, rather than exceptions for gas and oil and the waste that their fracking method contains. And I think that would be something that I would like to see our legislators trying to support us with, rather than exceptions to unlimited fossil resource that is only putting a Band-Aid on the wound. Something that would have our community prosper for generations to come, rather than take the chance of having mass exile from a contaminated, ruined environment. Thank you.
Anyone else?
I'm sort of a newcomer here. We've only known here for about 3 years. And I always thought that we would end up in Pennsylvania, and that's when the problems were going on in Pennsylvania. decided to come here. And I just have a hard time understanding why my animals and everybody else could be put at risk for groundwater contamination just because we don't live in a residential area, we live in an agricultural area. We're within the same town, and I just don't understand what the difference is between if my house is in residential and my house is in farmland, why I should be put at risk and why we're even considering that. If we abandon it in the residential area, why are we even thinking about, let's look at it to do it in any other area of town? And I just think, I agree with what everybody else has said here. And I think you really need to consider it because we did look in Pennsylvania. We looked hard in Pennsylvania before we came up here to look to buy property. And it is dangerous, it did contaminate wells and it did cause problems.
Could I ask your name for the record, please? I'm
My
sorry.
name is Betty Soulwater and I live in Oxford.
And then the last name was?
Soulwater, S-O-L-E, water.
Thank you.
You're welcome.
Okay, anyone else to speak?
Bruce Leonard, 44 Albany Street. Can you hear me? I got problems with my voice and it can only get so loud. Can you hear me? Can you hear me okay? Okay. I don't know how you can artificially draw a line between residential and agricultural. We have cars, trucks, heavy equipment coming up Albany Street, which is residential, continually from the agricultural area south of Green Street. Now, if you're going to allow staging in agricultural areas, all that stuff is going to come ripping up through the village into the residential area. There's no separating the two. I think they're being foolish trying to.
Anyone else?
I'm a pretty nervous speaker, but I'm going to read what I wrote.
Can you please state your name?
My name is Angelique Bacallier. B-A-K-A-L-Y-A-R. Just how it sounds. I'm going to read what I wrote because I get really nervous. As a landowner and business owner in the town of Oxford, living in an agricultural and commercial district, I would very much like to have a noise ordinance for non-agricultural noise. I, coming from a farming family, understand combines, grain bins, all that. I moved here. I moved into an agricultural environment. I understand it. For non-agricultural noise. Non-agricultural being tractor trailers that are not hauling for local farm businesses. I understand that farmers are vital and I would like an exception for the necessary purposes, not for non-agricultural or non-local activities, be they private or commercial. The times for quiet, I believe, should be set as the village times. I think that's around 10 p.m. to 7 a.m. Monday through Sunday, 365 days a year. We are a growing community. That is, the village is growing beyond its boundaries of a village boundary. You can keep the taxes in the village boundary, by the way. But we are a growing community and enjoy our peaceful community and the life and the sounds of that community. I understand that there's going to be a huge separation between, unfortunately, the farmers and the residents. I love farmers. Yours faithfully as steward of land, David Hales and Angelique.
After what she said, we're all neighbors, the three of us. And we live on Wilcox Road. And it's farming. I have 20 acres, whoever has. We have a neighbor who brings home an 18-wheel on the weekends with a reefer unit on it and runs it 24/7 till he goes back on the road. Now, I don't wanna hear it, and I said it, if I wanted to live near a truck stop, that's where I would have moved. Then we had a little problem and found out there is no noise ordinance here. What can we do to contain that, or stop it, or whatever? I know he can't leave it in the street, he was leaving it in the street. The sheriff did come and say he cannot sit in the road. Where we live on Wilcox, if you came around the bend late at night, I'm surprised someone didn't get killed. It was sitting right there. Now, he puts it in his driveway. I work for the state, I work on weekends, I have to be at work at 6 o'clock in the morning. That's not what, and the reefer turns on, then it turns off, then it just goes constantly. So I don't know how, she didn't really explain like what it was. I'm being more specific. This is what we have in our backyard. Yes, I understand farming equipment, but farmers usually between 10 o'clock at night and 7 in the morning are resting. This is a truck that sits out in front of our house all weekend long. And if he wants to bring it home during the week, that's his prerogative, so he says. How can we go about, as taxpayers in this town, to put a cease to this?
That is one of the issues that's being proposed here in this changes tonight, is to have a noise ordinance.
Well, I mean, tonight, I never came to a meeting, so all I heard was the fracking noises and stuff like that. I've heard dogs barking all night long too, but...
Changes proposed in this, to our regulation are to include a noise ordinance, which has been, section 76.
Okay.
It's an 8-page section specifically for noise.
But do you have noise ordinances inside in the village?
I have no idea what the village is.
Oh, okay, this is just, okay.
May I ask your name for the record?
Yeah, my name is Pat Casey, C-A-S-E-Y.
Anyone else wish to speak?
Delmar S. Franklin, Oxford, New York. I have to work a part-time job on the weekends because the county here pays my bills, but I have to pick up a little extra.
This is a public hearing, I understand.
Yes, I understand that.
Your picketing.
Okay, it has nothing to do with my picketing. I drive charter bus, that's what I was getting at, Mr. Wilcox, and I haul tons and tons of Pennsylvania residents, okay? So I hear from them, our roads in Pennsylvania are fantastic, but do not drink the water, okay? And this has nothing to do with my picketing, Mr. Wilcox. But you know, you get a few pros there, but most of them are, please do not drink the water in Pennsylvania, and the gas companies fix the roads up great, which obviously the town of Oxford does not have enough manpower or equipment unless they make them gas companies fix our roads, if they come in. I mean, so like I say, their main thing down there is they tell me is the roads are fantastic, but do not drink our water.
Anyone else?
I'd like to make a short comment. My name is Kathy Goldman. I live on Bradley Hill Road. In regards to the noise ordinance, I know you guys are working really hard trying to take care of all of these issues. Natural gas, oil drilling, all these materials being plants. And then you have actual issues that are in your backyard, like this truck that's running. Perhaps, just to save our residents from having to wait for all of this legislature to go through and all this gabbing back and forth on whether or not we should do this or do that, let's go back to basics and let's just take care of the noise ordinances for those things that are actually really happening and going on right now, and worry about the gas drilling and all of that amendments afterwards.
Anyone else?
Joan Leonard in Oxford. I just want to say that we live in an unspoiled, beautiful area, and I believe that it's our obligation to preserve what we have for future generations. In order to do that, some people who would become very wealthy from the gas drilling are going to have to settle to just keep working as honest, working citizens. Any short-term gains are going to be lost with the detrimental effects of oil drilling and fracking. So we need to not let there be a chance of that happening. It's not just us involved, it's our children and our grandchildren and this whole area.
Oxford. I feel it's somewhat premature to move ahead with legislation around special exception, given the fact that there's so much unknown about the health impact, potential for water contamination, and the number of earthquakes that we may experience if we move forward. I believe by putting this special exception into the planning board without oversight, as Paul talked about, that we're asking for a whole bit of stuff that we have no handle on. Perhaps we need to slow it up, deal with our friend's problem with noise, and hold off on this special exception. Thank you.
Anyone else?
I have something to submit from Dave Davis, who couldn't be here, so if I can submit that. And I have something written that goes through all the points that other people have already made. I mean, the addition of the material staging areas, the removal of oil and gas drilling from the residential areas, but the addition of, not limited to, the shifting of responsibility to the planning board, which isn't, and also the lack of any codified procedures for special exceptions. I mean, it's all, my husband and I and neighbors and these incredible people that we've met in the last 2 years have spent 2 years coming before this board with real issues and real problems that this industry exposes people to. I mean, these are real risks. This is water contamination. This is air contamination. I mean, see the information on what people are suffering from air pollution, from compressor stations and things. This is why kids are getting nosebleeds. These things, we've piled these things before you. And I have to say that trying to write up a letter today to respond to these zoning changes was like looking at a joke. I felt like it was with the exception of the noise ordinance, you know, which is a real thing, although I don't think it will hold any weight. I mean, we may be able to stop neighbors from running compressor trucks, but we're not going to be able to stop the gas industry from running compressor stations. They're just going to ignore them. They're just going to take the fines, right? Because they're small fines, and they have special exceptions for those too. I wish we didn't have to go through that. I wish that there were some real changes in this. And the biggest change, the biggest thing that I don't think is addressed is the agricultural area. When I went to pick up a copy of the new zoning ordinance from Jim earlier, a couple of weeks ago, I looked at the map that's there, the one that was sort of initiated by Ron but was completed by the county, and it's like 90% green, right? It's green. It's the color of Jim's shirt. It's beautiful. And when you drive around in these roads, and when we look out from our house and we look out from our neighbors' houses, we see cornfields and alfalfa and timothy and clover, and they change, and the farmers come through and they hay, and they changes with it. It's named an agricultural district for a reason, because that's what this area has been. It's been a dairy region, and now there are people growing hops, and there are people experimenting with broccoli and other things. We've seen the farmers market explode this year with people bringing their wares to it. To not protect, this is a heavy industry. This is not what we thought this industry was in 2007 when those words were added to that revised zoning. This is heavy industry, and it intends to be everywhere it can be, with pipelines, compressor stations, 5-acre well pads, and these things don't disappear. And I just want to make a plea for it. I mean, it's one of the most beautiful places I've ever been. And people, we have friends who come and visit and they go, I've never been anywhere so beautiful. And we have water, we have land, we have all these things. We have food production, we have people who know how to raise animals and know how to raise food, how to grow food. And we're gonna give that all up. And I just want to make a final plea, and we've got 3 farmers who sit on this board. This is, it's worth protecting. So, there's my comments.
Anyone else? Anyone else who would like to speak? If not, I would entertain a motion to close the public hearing. So moved. You have a motion?
Ellen made it, I'll second it.
Helen made the motion. Helen, second. Okay, discussion? Motion to close the public hearing. If not, all those in favor of closing the public hearing?
Aye.
Opposed? Okay. I certainly thank the people for their input tonight. I think it's only prudent that we not make a decision on these changes tonight.
Yes.
Give ourselves time to think about what's been said. We will come back together on the 10th of September, and that will be on our agenda to see what the outcome will be, whether it be to adopt it or to make changes, further changes, or whatever. So thank you for your participation. Okay, one of the issues that going through the process here, needs to hold on. How about yes?
I put that at
Leave that? Leave that? Yeah. Could I ask you to move on outside so we can finish? If you want to stay for the meeting, that's fine, but we can't have as much noise. If you want to visit, please move outside.
There's a town board meeting.
Thank you.
I got a booming voice.
Okay. Okay, as I was going over the procedures here, one of the things that we need is a seeker form from the planning board. S-E-Q-A. From the planning board, and also we're supposed to have one from the town board, saying that there's no substantial environmental impact to the changes that have made. It doesn't address what's already in the ordinance, it's the changes. So last month, we made a statement and a resolution that the town board felt there was no, I'm trying to find the word here. There's no significant environmental impact on the proposed revision, but I think we should have on file the form. And so I think that we need to come back together
In the planning board.
and the planning board having the same.
It's just your environmental form that you always fill out for short subdivisions. It's a short environmental
It's
form.
just a matter of, there is an impact, there isn't an impact, and have a resolution to it. So, and we'll have one at the next meeting and do that, so that that's in place. As I say, we made a stab at taking care of that, but I think we should have the source there. The other thing I'd like to say is that we did get a lot of input tonight, and that's good. And I think that we really do need to spend a few days thinking about what's been said. And I think everybody got copies of the written material that came through.
I have one more question concerning that also. Concerning the printed 239 review, we need we need that piece of paper from the 239.
Paul gave it to you.
Yeah, we did.
I think Jim has it on file, but we need to.
I got this, if you don't find it, holler.
We just want to make sure that that is on file.
I think Paul brought it to our last meeting, but I was going to.
And I think it would be good, the attorney sent you a letter regarding your conversations with him. Is that correct?
I believe he did.
I thought he did. That would be good to have on file also.
There's been a few minor incidental changes that I could look at.
Okay.
What else we got? We got the bill.